Hello guys, this is Olayeni Dieko Daniels, popularly known as Dieko Spectre, and welcome to another episode of Dieko Talks Law. On today's episode of my lecture, I would be discussing about express and implied contracts. In my last class, I spoke about formal and simple contracts, and then I told you that there are three forms or classifications of contracts. We have formal and simple contracts, which I discussed in my last class. This class will be discussing express and implied contracts. In my next class, I'll be talking about bilateral and unilateral contracts. Now, if this is your first time of coming to my channel, please make sure that you click the subscribe button below and also click the notification bell so that anytime I release a video which is going to be of interest to you, you'll be one of the first set of people to watch that particular video. So, as is my methodology of teaching, I'll go to my notes now, after which I'll then explain the whole concept of express and implied contract. So let's go straight to my notes. A contract is said to be express when the terms are clearly stated, and implied contract when the terms are not so stated. However, in an express contract, the extent of the respective obligation of both the offeror and the offeree are clearly stated either orally or in writing. Now, the unique advantage of an express contract, particularly when it is written, is that the parties can always refer to it for interpretation in cases of controversy. A good example is where tenders are invited for a construction work. Each applicant who responds to the advert will clearly state all the material terms, such as the quality of the material to be used, durability, prices, guarantee, term or mode of payment. An implied contract is one which the terms are not so stated either orally or in writing. The court, in such circumstance, will normally construe the existence of a contract from the conduct of the parties rather than from their words or correspondences. For example, a passenger usually enters a bus without dialogue between him and the conductor or driver. Yet, to all reasonable men, his action implies that he will pay his fare, while the bus owner is obliged to carry him safely to his destination, provided it is on the route of that bus. See the case of Brogden versus Metropolitan Railway Company. And in case you would love to read the full case, you can read the full case on Precious Case app, where you have the link in the description below. Download Precious Case app to read the full cases of any contract law case that is cited in this particular lecture or in subsequent lectures. Now, a classic case of a contract concluded by conduct occurred in the case of Attorney General of KADUNNA and others versus Victor BASSEY ATTA and others. The Kaduna State Ministry of Works and Housing invited the respondent, that's Victor BASSEY ATTA, who were architects, to design a building, and they agreed to do so after several meetings and correspondences, during which the respondent made it clear that the cost of the project was going to be greatly in excess of the 1.5 million naira proposed by the ministry. The latter finally wrote to the respondents in July 1977 requesting them to furnish the ministry with an estimate of the project, including the services and involvement of your fee. I'm now quoting what they said, both pre and post contract services. The respondent regarded this as an authority to go ahead and produce the design, and consequently wrote back providing the required information, adding that the designs and estimate will be submitted in September. The ministry gave no response to the letter. Subsequently, the ministry did not write back to inform the architect not to do the design. When, however, the design was submitted, it refused, that's the ministry, refused to pay for it on the grounds that the design did not suit purpose and therefore was not acceptable. The High Court granted the architect's claim for professional fees, and the ministry appealed on the ground that there was no valid contract between them and the respondent. Dismissing the appeal, the Court of Appeal held that the acceptance of an offer can be demonstrated by the conduct of the parties as well as words and documents. this is what happened in this case. That is the fact that the whole contract was made by their conduct and not necessarily by the words and all that. The court construed a consultancy agreement from the correspondences of the parties and their conduct. Now, I want you to focus your attention more on, this certain part that I'm about to read again. After several meetings and correspondences, during which the respondents made it clear that the cost of the project was going to be greatly in excess of 1.5 billion proposed by the ministry, the latter finally wrote to the respondents in July 1977, requesting them to, in quotes, that is in their own words, furnish the ministry with an estimate of the project, including all the services and involvement of your fee, both pre and post contractual service. After this, the respondent regarded this as an authority to go ahead and produce the designs, and consequently wrote back providing the required information, adding that the design and estimate will be submitted in September, and the ministry still didn't give any response. Neither did the ministry tell the architect not to make those designs. Those are very key information for the explanation. So yes, express contract is usually not problematic, because you know what an express contract is. There is offer, there is acceptance. Both the offer and the acceptance was done expressly in such a way that the parties knew that there was an offer made, the other party also knew that there was an acceptance. And not just that, the terms of the contract are most times also as express. That is why I gave the example of the tender. For example, I want to build a house, and I'm telling the people that are going to build the house, that's the architects, I'm telling them to give me the breakdown of how they intend to build my house. That's an express contract, because now they are making the offer. I'm going to have a lot of tenders. A and B architect, this one Lola, and this one architect, this one and this one architect. Do you understand? Now, when all those architects submit their stuffs to me, I then scrutinize which one of them I want to pick. Now, in what they are giving me the terms of the contract along with an offer. Do you understand? So they are telling me that they are going to use Dangote cement, they are going to use this, they are going to use that. I can see everything clearly stated in the tender that I'm receiving, and then I accept it and say yes. So you can see what an express contract is. When you're talking about an express contract, the offer and the acceptance are done expressly, and also the terms of the offer can be seen. That okay, these and these are things that you want. But you see, in an implied contract, which is the most problematic one, for example, the example that I gave in the note, the first one was regarding passenger and driver. Except you are in a country like Nigeria where everything is by shouting and noise. For example, you want to go to Yaba, you shout Yaba Yaba Yaba, everybody can say I will and all those kind of things. Hello, the 15 and the change and stuff like that. I'm speaking Yoruba. I'm sorry for those who are not Nigerians that are currently watching my video. So I'm speaking a particular language. Now, what I'm saying is, in Nigeria, for example, you see conductors shouting, literally hauling. You are going to this particular place, please hold your change, and stuff like that. But if you're in a more sane country where you can see buses stop, and you can literally see where the bus is going, you don't need to shout or make noise. You go into the bus, you sit down, you would have paid your fare, stuff like that, without even having to say a word. You would have done everything. Everything is by conduct. The driver stopped, and then you entered, making an offer for the driver, and then the driver moved, accepting your offer. You don't even know who the driver is. You don't even know if the driver is an Igbo man or a Yoruba man or whatever it is, but you have made a contract. Do you understand? That is an implied contract where the terms are also kind of implied. Now, another way to explain this is using relationships, for example. So when somebody wants to ask another person, will you be my girlfriend, expressly, you can see it. Gone are the days where we used to have very express contracts in terms of relationship. When we were in secondary school, those times when we didn't have phones, and even those of us that had, the highest we had then was to go. Before that time, when things were still very traditional, when you want to ask a girl out, you basically have to write letter and beautiful words and all that. For those that can relate, you understand what I'm saying. Now, at the end of the letter, you most likely write, will you be my girlfriend? Do you understand? That is an express offer going to the girl, and then the girl accepts your offer. Do you understand? That's an express contract. But you see, in relationship of today, we don't usually say, oh, it's going to be very rare to find somebody who is going to actually expressly ask, will you be my girlfriend? Now, what we have is most of situationships. So basically, you just have, oh, I like you too, and it's not like you people, clearly told yourself that you are in a relationship, or you ask yourselves out. But your movement is such that if the court should look at it, objectively, that is actually a relationship. But you guys did not tell yourselves. So, for example, as a girl, you like a guy, you're currently talking to the guy, and you guys are like having a very great bond, and other guys are coming in. The guy has not expressly asked you out, but then you are giving other guys red card because there's already someone who has filled the position in your life, yet he has not expressly asked you out. Do you understand? So you guys go on movie dates and all that, like friends would naturally do, but in your context, it's not like you guys are natural friends, because then there's something else. You understand? So when you're talking about implied contracts, like I just used the whole analogy of relationship, it is not expressly stated between the both parties that this is it. Do you understand? But the court will look at the agreement. The agreement in terms of their conduct. How has this person acted? Then what did this person do? So if we are supposed to scrutinize the relationship, for example, the boy, in this case, now has been buying the girl a lot of gifts, doing a lot of things. He even told his friends that the girl is his girlfriend, and the girl knows that, the boy's friends know that she's his girlfriend. You know that kind of arrangement where, they, like, by conduct, everybody around the boy already ascribes the girl to be the boy's girlfriend, and all of a sudden one day maybe one rich man just came from nowhere, and then the girl is not like, well, he did not technically ask me out. Nigerian boy. But then that she's trying to rely on the fact that he didn't say, will you be my girlfriend? But in that context where, other people could see that there was a relationship there and all that, and, by their conduct, they've already acted like they were in a relationship together. They've gone on dates and all those kind of, things, the court can infer that there's a relationship. The same way in a contractual agreement, the court can look at what has this party done, what has this party done, what have they done. Do you understand? So in the case which I gave to you, you will see that the party there, that's the architect, they told them expressly, you see this your contract that you want to do, it's going to be more than 1.5 million that we earlier stated. They did not say anything. They said give us estimate. They gave them estimate. They did not say okay anything. Then they gave them designs, and then everything that happened, you just see that the ministry was just keeping quiet. That it was time to pay. The ministry said, oh no, there was no contract. There was no what? You can see that everything that you asked for, they basically gave, which means that you were giving the offer, they were accepting. You were giving the offer, they were accepting. So in your conduct, we can infer a relationship. We can infer an agreement. Do you understand? So express contracts, they are expressly stated. You can see them. Do you understand? This one is asking, will you be? This one is saying yes. Do you understand? But implied, they are not expressly stated. You have to look at all the facts. And most importantly, note this before you leave, that one hurdle about implied contract is the fact that it is difficult to prove. Do you understand? Because except the guy has kept WhatsApp messages and stuffs in the relationship, that's the situationship I painted earlier, and you can literally bring somebody from the supermarket to prove that, oh, we went shopping, bring one of your friends to prove that, oh, she agreed, do you understand? Unlike when you just try to prove, if you go back to the olden days where you bring the letter where she said, will you give my girlfriend, and this one said yes, bam, you've proven. But in a situationship, which is more of an implied contract, you then have to go through the hurdle of yes, so he said that I should do this, he said that I should do this. Like the architect had to, if you read the full case, you see that the architect had to do a lot of things to prove to the court that there was actually an agreement, which he would not need to do if he just brought a document. My lord, he signed it that he was going to do it. Simple. That's like the big difference between an express contract and an implied contract. So I hope that you understand. In my next class, I will be talking about bilateral and unilateral contracts. I'll see you in my next class.